Hello, welcome to Business Immigration. This week we start the discussion of permanent immigration based on employment, investment, and other business activities. In short, EB, employment base. And this is after we finish our discussion of the non-immigrant side of the program. Permanent immigration characterized by and large, first of all, by the intent of the person who's coming to this country. Non-immigrants come temporarily with an intent to leave at the end of their intended stay, while immigrants intend to stay here permanently. Most people who achieve a permanent status in this country get a green card or lawful permanent residency. What what is different is the way that they get there. There are three main avenues and many other smaller one, but the main avenues is family base, diversity lottery, and employment base. From these three, the diversity visa is about 50,000 a year, and the employment base and family base share almost 480,000 um, applicants for green card. Between family base and employment base receive about 140,000 visa or green card numbers, or it's a little confusing, but it's referred to as immigrant visa number or short visa number, but don't mix it up with non-immigrant. It's immigrant visa numbers. Um, Within the employment base, those 140,000 visas are divided within five different preference categories. We're going to look at them all and see how they operate in helping or making it harder for certain employer to obtain green card for their employees. The road to permanent residency, LPR is lawful permanent residence. This is the short term we use all the time. It generally consists of two phases. One, establish eligibility for an immigrant visa under one of the categories that we mentioned, EB, FB, or DV, employment-based, family-based, or diversity visa, or some other smaller group, as we said, and establishing a priority date. Priority date, as we see, it's a key element in the process because it basically where the person is in line to receive a green card. When immigrant visa number becomes available, then after the eligibility is proven, the person can proceed to get the green card in one of two ways. One is a consular processing abroad, if the person is not in the United States, and the other one is adjustment of status if the person is physically in the United States and is eligible. There are additional eligibility criteria for adjustment beyond being in the US. For example, the person should have never worked without authorization, overstayed a visa, and so on. The second phase of AOS or consular processing is the same for everybody pretty much. So the roads to permanent resident in graphic form, we are looking at the employment and business avenues towards LPR, and the DV and family base are also there. Once the employment-based petition is approved and the visa number is available, then a person can proceed to adjust their status to a permanent resident or consular processing. Now, don't mix adjustment of status with change of status. Adjustment of status refers specifically to a change from a non-immigrant to immigrant, while change of status is from one non-immigrant status to another. Okay, how are we allocate or how the law allocates the 140,000 or so immigrant visa per year to between the five different categories within the employment-based system? Um, EB1 to 3 are pretty much in hierarchy, which usually means that if you're in a higher category, 1 is higher than 2, 2 is higher than 3. If you're in a higher preference category, usually your wait time, if any, will be shorter. Not always. This is the mechanism of how to determine, of how the State Department determines which numbers and which categories move forward or backwards is very complicated and is based on some assumption and some information, um, and it's not always 100% consistent. And that is something that we're going to discuss in a little more detail. EB4 and EB5 have a different availability schedule that is separate from the EB1, 2, 3, but they're also counted under those 140,000 visa. In addition, the law prescribes that in addition to being in preference, being receive a green card based on a preference, there's also a limitation in the law that no country can receive more than 7% of the overall green card allocated in any year. This is very, very um, hurtful or damaging to individual from very populous countries like India and China, or countries that send a relatively high number of individuals to the United States, like Mexico, the Philippines, the Dominican Republic, and so on. Those countries, because there are so many applicants and no more than 7% can go to those countries, have very long wait line in certain categories. Um, so this limitation is obviously far more crippling than the preference categories. The priority date are set monthly by the Department of State by what is called the Visa Bulletin that is published by the State Department every month. The Visa Bulletin is determined by the Department of State's Visa Office. It issue monthly. It basically by priority date decides or tell people when they can apply for a green card. Uh, right now, as of 2016, it publishes two dates each time they for each category. One is the date of filing. This is the date when uh, basically the State Department begin contacting the people for consular processing, and it's in some cases USCIS agrees for to people to file at that date. The other date, the final action date, is the actual date when a person can get the green card. Sometimes there can be a long difference, a long time before a person can get their green card, but if they can file already based on the first date, they might be in a better situation because they can get other benefits and they can, we're going to talk about portability later on in the course, um, and they can also get employment authorization and travel documents, which might help them in some other ways. USCIS doesn't always agree with the State Department, and oftentimes, especially in the employment categories, stick to the final action. So they would not accept, USCIS will not accept adjustment of status application based on the filing date that the State Department published, but rather on the final action date. So that's important. The USCIS right now, every month, announces whether they accept or not. This is taken from the Visa Bulletin. You can see how it is organized. It's organized by family-based, employment-based. This is a printout of the employment-based part. You can see these are the final action dates, and you can see based on the preference category. This is first, second, third, and so on, and then chargeability area. You can see whether a person can apply. So if someone is in the second preference from all chargeability areas, meaning from most of the world, they can apply for an immigrant visa or adjustment if their priority date is earlier than February 1st, 2014. If, however, they are from India in the second preference, they must have priority date before February 22nd, 2005. This is already more than 10 years of waiting. And you see this is mostly because of the per country limitation. Wherever you see a C in the Visa Bulletin, it means that the priority date is current and the person can immediately apply for the green card or consular processing. This is the second date that we talked about. This is the dates of filing when the State Department traditionally on that date, which is what they assume is about a year before a priority date becomes current, contact people to start get their document in order to get consular processing done. USCIS would sometime entertain that date and accept petition filed on that date instead of the final action date, which is the traditional historical date where a person can get a green card.